Hi, everybody. Let me introduce myself in case you don't know me. My name is Deborah Oppenheimer. I'm one of the partners here at Altitude Community Law. Right now, you should see the PowerPoint presentation taking up most of your screen, hopefully, and I'll be hopefully small over on the left-hand side. On the right side of the menu, you should see a private chat icon. Please use that icon to type in any questions throughout the presentation. Questions, I'll try and address them as they come up, but if I get too bogged down, I might wait to the end to finish up with them. If you have any audio or video issues during the presentation, please click the No Audio or Video button below the presentation on your screen and follow the instructions. One CMCA credit will be automatically generated and emailed to you after the webinar, assuming you attend the entire program. The credits aren't transferable. If you have any problems with that, please email Jessa Ledesma, and that's Ledesma, so J Ledesma at Altitude Law, or call 303-991-2086 if you have any questions about the webinar or getting your CMCA credit. Lastly, there'll be a survey that pops up at the end of the webinar. Just say I did perfect on everything. You know how that goes. No, honestly, we really do want to hear from you. Please let us know what your thoughts are, because that does help us in our presentations, and it helps us as we work through them and make sure we get you what you need, because obviously we don't want to waste your time. All right, so let's jump into this. As most of you know, I always present to you kind of where you can get these resources. As we're in the crazy legislative session this year, I think at last count there's 25 bills that we're monitoring. If you watch our website and our blogs and our newsletter, we'll let you know what's going on and try and help you keep track as we're trying to keep track and stay on top of that. You can also check our Twitter, Facebook, or LinkedIn pages to kind of help get you information to answer your questions or board member questions. So what are we going to talk about today? I'm going to give you a list of all these, and then when we kind of get through some preliminary stuff, we'll come back to it and start going through line by line each of these different things. But when we're talking about nuisance type violations, we're talking about noise violations. Could be loud parties, could be loud TV, screaming, fighting. We get all these kind of complaints as board members bring them to you, or homeowners are bringing them to you. Could be barking, howling animals. Nuisance also covers, because those lovely nuisance provisions are so broad, smells, odors, whether they're cigarette, marijuana, whether it's cooking smells. It could be uncleanliness. You could have someone who's, hoarding maybe, and they're off, you walk past that unit and the smell just kind of hits you in the face. It could be homeowners who have severe allergies or issues with painting or new carpet. All kinds of these things kind of pop up under that nuisance violation. A lot of the ones that are really, that just fall into that category are very short in duration, right? Trash on the property, or it's in the cans and the cans are left out, or that it's left out too early, too late, it's not properly secured, dogs are getting into it. Dogs is a huge one as well, whether they're off leash, they're not picking up after their dog, parking issues, pool violations. These are issues that all pop up as short term and often are under the nuisance violations. So why is it so difficult? Well, part of the problem with most nuisance violations is it's subjective, right? It could be something that maybe isn't a big deal if it's once, in a blue moon, but when it's every day, it drives you insane. It could be the timing of the irritation, right? Is it, at 2 in the morning and their TV's so loud that, you may as well be watching the TV program because you can hear every word. Or it might be the amount of smoke that's coming in. And, part of that has to be an expectation, right? You're in a multifamily community. There should be an understanding. You're going to hear some noises. You're going to hear your neighbors. You might smell what your neighbors had for dinner. I mean, it's going to depend on how it's built and such. And so part of that is that expectation and what they should be used to, right? A lot of homeowners who are in multifamily units think that they should not hear their neighbors or see their neighbors, and that's just unrealistic, right? And when you get to court and when you're talking, what can you enforce or what can you enforce in court, you need to understand that judges are not going to look at something in a vacuum, right? They're going to look at this and say, that you live in a multifamily unit and you're mad you can hear the water in the pipes between the walls. Hi, that's going to happen. You have to have some reasonable expectation. A lot of times the problem becomes the lack of specificity in your governing documents, and or no mention whatsoever, and your board tried to create some rules to cover things. Sometimes the discretion of the board in when they should or should not take action becomes the issue, because they're not certain if they should, they're not certain if they shouldn't, and their position and the homeowner's position are opposite, and that causes strife. And or sometimes the conduct's gone on for years and you get a new board and all of a sudden the new board wants to change things, and that's the problem. And so we get all of those combination that causes these issues and makes this a very messy, difficult problem. And then that doesn't even touch upon the fact that we have 1137. And 1137 tweaks all the rules. All of these classes regarding what we can do, what we can't do, had to be tweaked, had to be changed, because 1137 sufficiently ties our hands that a lot of this stuff, from a manager's perspective, it might be a good thing. We can't do anything. Might not be, and or it causes a rethinking of how we're going to approach it, because it's very different. Obviously, we always have to start on what authority do we have, right? And I know this is a preliminary, but you always need to start here. You always need to get your board starting here, because every owner assumes that the board or the manager can fix everything, and you are their one-stop, hi, make this go away. And that's just not rational, and it's not realistic, because a lot of times there's nothing in your documents. Many years ago, I had a community that was single family homes, and there was absolutely no restrictions on dogs. And in fact, the declaration actually wrote in there, any complaint about dogs had to be taken to, I think it said animal control. It absolutely said the HOA is not going to deal with this. And homeowners, because they'd moved from one community to another, and there's always something in the documents, there's always something in the rules, they just presumed there had to be a rule against this dog barking. And the fact was, the declaration actually said, nope, not our problem. Call animal control. And so you really need to start with, is there really a rule or is there really a covenant that prohibits something? And if there's not something, then your first step is to be very careful and very clear to your homeowner when you say, there is not a violation, okay? There is nothing in our documents that prohibits this conduct. You don't want to say, hey, that's a neighbor to neighbor, go talk to your neighbor, not my problem. Because that's not going to get them off your back. That's just going to get them yelling at you for not doing your job. So you want to be clear, it's not that you're not doing your job, it's that you have no legal authority to take action. And so you want to say to them, this is not there. This is not something I can handle because it's not in your documents. So you're going to have to look for a city code, a city ordinance, call code enforcement, call animal control, but you want to refer them to someone else, right? The other thing that you have to be careful about, and what frequently happens and what I find my owners running into problems with, is like a noise violation. There might be a covenant that says quiet time is after 10 o'clock. Nobody's should do anything after 10 o'clock that's loud and annoying to their neighbors. And of course, there's also city, disturbance laws that kind of mimic the exact same thing. And so as a manager, you might say, call the police, right? And when you tell them to call the police, they call the police, but they tell the police about your covenant. And the cop goes, not my problem, right? And the cop doesn't share with them that there's also a city ordinance against the noise violation, because they've just got the ability to walk away from you and say, oh, we don't handle covenants, that's civil, and go do something else. And so they don't handle it. So when you do have two rules, you always want to make sure you tell your homeowner, call the police and tell them that the noise violation violates the city noise provisions, right? The ordinances in the city. Or if you're in the county and there's barking dogs, there are barking dog violations in county restrictions. Make sure they reference that and not reference your covenants, because what you're going to get is something that is not my job, go call somebody else, right? The other thing that you want to be clear about is some things when the declaration isn't clear, it can be clarified by adding to the rules, and you can fix it and tweak it and make it better. And sometimes you can't. So you want to take those a little bit at a time. Okay, so when you're talking about clarification, you want to be very careful that you don't try and create a rule where a covenant must be used, right? What's a really easy example about that, right? Renting. You cannot have prohibitions about renting in rules. Those can only be added by the declaration. So if in fact your documents aren't clear, but they mention it, you can clarify. So if your documents say owners can have a reasonable number of dogs, you can clarify that to say, by rule, the board determines a reasonable number to be 2. But you can't, if the documents are completely silent, just create a rule, right? When you create a rule, when your declaration is completely silent, there's nothing in the declaration, and you create a rule to try and address the problem, you can be attacked for that rule and told that you're trying to amend the declaration by rule, and that's illegal. So you want to be careful with that. You can clarify it. Now, if there's nothing in your documents about what can be done on common element, on property owned by the association, the state law, the declaration can, even if it's silent, even if nowhere in the declaration does it say anything about what you can do on the common property that's owned by the HOA, Kiowa, pre or post, has the right to control the use of the common elements. And so you can draft a rule on what happens on common elements. And so that's the one area that even if your declaration is silent, you can come in and write a rule about what happens on the common element, okay? You can't do that for individual lots, and you definitely can't do that for use inside a lot. Use inside a lot or use on the lot, you've got to see something in the declaration. If it's inside the unit, it has to be in the declaration, okay? So just be aware and really work with your counsel when you're looking at, should you add a rule, and never add a rule because of the conduct of one owner. That will always bite you, okay, always. All right, I've already seen some comments about this, and they're absolutely right, which is the problem with nuisance provisions is they're so broad and they're in almost every declaration. This is the language that I see a lot in a lot of declarations, and it talks about unreasonable annoyances or, unreasonable disturbances. Well, what's unreasonable to me and what's unreasonable to you are going to be completely different, right? And it talks about board's reasonable discretion, right? The good news, like if you have in this language, it actually talks about dangers or risks to the property or risks to the persons, right? Threats to the health or safety. Those kinds of things are very useful. And we don't often have that kind of comment in the nuisance provisions. They're very, very general most of the time. And that's what makes it very difficult, right? It's very broad. And what one owner thinks is a nuisance isn't. Kind of my unwritten rule has always been on nuisances that I need 3 different people in your community. And those 3 can't be related in the same household or anything else. But you want 3 people that are going to agree that it's a nuisance before you're going to move forward in court, okay? So let's talk about 1137 because it tweaks what everybody can do on this, right? We all know that's what's really making our lives a little more difficult, which is you need to determine, is the nuisance a threat to public safety or is it not a threat to public safety? And the problem being is if you've got a nuisance that is not a threat to public safety, it has to continue nonstop ongoing for 30 days. So I'm going to go back to one of the questions that popped up because I wanted to wait till I got to this slide and answer it. Because the question was short-term renting, right? And you get an owner who's doing short-term rentals. Now, presuming that you have a prohibition against short-term rentals in your declaration, and you said, look, this is a violation of the covenants. Well, by statute, you have to give them 30 days to cure it. Well, okay, it's a short-term rental. It's less than 30 days. It's always going to cure itself within the 30-day period. Short-term rentals is not a violation of health and safety. So how do you ever get to be able to stop a short-term rental, right? How do you stop it when it's never going to be 30 days, right? Because that's the definition of short-term rentals, are less than 30 days. And the statute says I have to give them 30 days to fix. You're never going to get to fine stage, right? So now is the start of how we're going to start thinking outside the box. How do we deal with this, right? Well, one way to deal with a short-term rental, and we're going to take each of these a little at a time and then try and talk about what we can do and how we can deal with them. But for short-term rentals, draft your rules to prohibit the advertising for the short-term rentals in addition to the short-term rental, right? The short-term rental itself is in your declaration. So you can tweak and clarify it and add to a rule that says even the advertising of a short-term rental is part of the violation. Well, people don't pull down their advertising. It's going to stay longer than 30 days. So that's what you're going to use to be able to get to a fine stage on short-term rentals, right? And that way you get around 1137 and you address the violation. As to the question of, you sent a violation for short-term rental and the next thing you know, you're being threatened by somebody at your door. Anytime you're threatened, anytime, call the police. Never, do you want to deal with any kind of threat to yourself, to your property in any respect by doing anything other than just calling the police. If you're being threatened, that's for the police to handle. So, given 1137 has put us kind of in this horrible position, we need to start thinking about when we can use self-help, right? When do we have the legal right to just fix the problem as opposed to sending a violation letter? Because fixing the problem using our self-help abilities in the declaration may be your only ability to handle some of these things now. And because of that, because you may not ever be able to get to 30 days, right? Dog poop. It's a one-day event. It's not going to continue for 30 days. You're not going to leave that dog poop there for 30 days. You're not going to mark it with a flag and put a date on the flag so you know which piece of dog poop to know whether your homeowner, removed it within 30 days. You're not going to play that game, right? And so we have to think outside the box to get around 1137, and that's going to require us dealing with matters and using our self-help allowances in our declaration. And what do I mean by self-help? If for some of you guys who are new, if your documents have provisions that say, if an owner fails to cure something after a set number of days, the association can cure it and bill the homeowner. That's what I'm talking about when I'm talking about self-help. Looking for your declaration provisions that say you can go in and fix it. And when do we want to do that? When we're not going to be at risk and when we're not going to put our contractor at risk. So we want to think through those things. I'm not telling you to go put yourself at risk to cure these things, okay? I'm going to look at these things on kind of a case-by-case basis of when can we use self-help, not put ourselves at risk, cure the problem, and get around that bizarre 30-day demand of 1137. Sometimes your only option is going to be to call the police. That's your only option because it's a short-term event. You're never going to get your 30 days, and the only way to deal with it's police. And sometimes it's going to be you're going to tell your neighbor to talk to their neighbor. They're not going to like it, but that's kind of going to be your only option just because of what 1137 has done to us. So let's go back to that list that I started with and talk about them one at a time, right? Let's go through some of these and look at some of these. So when we're talking to loud parties, loud TVs, that one, you're going to look to city and county ordinances for disturbing the peace, right? You're going to refer any homeowner who calls you to city and county disturbing the peace. That's all you can do. I had a question earlier, what about wind chimes? Because it's a noise and it's annoying, but it's only a bothersome thing when it's windy. That one, there's nothing you can do other than tell your homeowner complaining they have to go ask their neighbor nicely to take it down when it's windy. Because there's nothing else you can do. If it doesn't continue for more than 30 days, you're not going to get around 1137. Wind chimes are never going to rise to the level that it's going to be disturbing the peace. So you have no options. For a manager, your answer is, I'm sorry, I can't do anything due to this law. And all you can do is go talk to your neighbor. Obviously, your homeowners aren't going to like that, but that's the only thing you can do. What do we do about screaming and fighting? Again, that's another thing that you're going to want to call the police on. One, you're not going to want to get involved in that to begin with, right? That's something that when you're looking at, you don't want to step into the middle of screaming and fighting. You don't want to be, I will tell you from an ex-district attorney's position, you never want to step between, a couple that's screaming and fighting. Most cops get hurt when they try and separate, a man and woman fighting because the person they pull out of it stabs them in the back. It's like trying to stick your hand between two dogs that are fighting. It is not a good situation. You, the manager, you, the board member, do not want to step into this. And so that's definitely call the police on that situation. The next question is, okay, once the police are called, can we do anything? Well, you can send your fine notice, but again, given it's a one-day event, you're never going to get to the fine, right? Because that has to continue 30 days unabated, and then you can get to a fine. So can you send the letter following the police call out? You can. It's probably not going to do you any good. Now, if it's a tenant, it might be putting the owner on, it might be good simply because it's putting the owner on notice that the police got called out for the loud party. So in that circumstance, when the neighbor calls for the loud party, you tell the neighbor, call the police, and then when they get a police report number, give it to you and you'll include it in a letter to the owner. And then the owner may decide, because they're constantly getting these notices that the police are constantly going to their unit, that they may want a different tenant. You're not going to get to fines, but you may get the owner to decide they need a different tenant simply because you're sending the violation letters every time there's a loud party. It's hit or miss whether it's going to be helpful or useful. The police aren't going to like it because they're going to get called all the time, but there's nothing much you can do with anything. A lot of times I have board members and or owners who are very frustrated because the police get called for domestic violence cases all the time at a house, and they want to know, the police are called all the time, can't I enforce the covenant that says a violation of law is a violation of the covenants? And my answer is still going to be the same answer. It has to continue for 30 days or you can't get to fine stage. So, the cops are getting called all the time, but there's really just nothing you can do with that, okay? So tell your neighbors who are frustrated, call the cops. That's all you can do on those, okay? It's not a great answer, but it's what you're going to do. For the barking and howling animals, the answer is the same. Call animal control, call the police, call somebody who has an ordinance that prohibits that barking, howling. And there are, even in the county, if the dog or dogs bark nonstop, that's a violation of county code, and you can tell the neighbors to turn it in. Can you ever say, like, the screaming, the fighting violates the health and safety? You're not in the house, so how are you going to testify there's a violation of safety? Do you know who's being threatened, or do you just hear that they're screaming? That's a hard thing for you to determine whether or not there's a health or safety such that you can use a 3-day letter. But again, if you get 3 days in a row of screaming, maybe you can get to the fine and maybe you can turn it over as a health safety. That's one of those things that you just don't know about, right? Question: self-help requires court-ordered permission, right? No. Here's the deal with self-help. Your documents, meaning your declaration, must state that, in fact, you can use self-help. And then if, in fact, it's in your documents that you can do so, you can. What requires a court order is a cop. Cops will not come out to the property unless there's a court order in play. So if you want protection for your contract worker who's going to come to the property and look and see if, in fact, you've got contractors out there and you want to make sure they're protected, the cop's not going to come out without that court order in place. All right. So you don't need a court order to take self-help, but if you want the cop to be there to protect your contractor, you'll need a court order in place to do so. And that's a problem because you can't get it to the lawyer, me, until it's been 60 days in play. All right. So you're not going to be able to have a cop there, and you're not going to be able to court order there because of the 1137. One other thing you need to think about. Owners have a right to the quiet enjoyment of their home. Okay. And I've had many times, been doing this 20 years, where one owner sues for the constant noise disturbances of the neighbor. Now, if in fact you have one homeowner who sues the HOA for not enforcing noise disturbances, we have a very easy defense at this point, which is there is a legal defense of impossibility, meaning I legally cannot send a letter to the neighbor because 1137 says all I can do is send a letter and give them 30 days to stop. The noise always stops within 30 days, so I can never get to fines and I can never get it to a lawyer. So if in fact your HOA gets sued by, John Smith because John Jones won't be quiet, you can tell Mr. Smith it's impossible. I cannot go to court because 1137 prohibits me from doing so. So if they say, I'm going to sue you, you can say, go right ahead. I can't do anything. But you, Mr. Homeowner, have the right to sue your own neighbor for noise violations, and you can sue them under your common law right to quiet enjoyment of your home. Okay? So that's something else when you have the noise disturbances that are constant, the homeowner who's crying to you, do something, you can say, sue your own neighbor because I can't. Okay? And again, you can always call the cops. What about smells? Smoke smells, cigarette smells, cooking smells. How often do smoke smells or of any kind, whether it's cigarettes or whether it's marijuana, last more than 30 days? Your 1137 is still going to prohibit you from doing anything. You can send the first letter. That's all you're ever going to get to. You're never going to get to fine stage because it's never going to, continue. Now, if you've got somebody who is smoking so much that it's nonstop, continuous, more than 30 days, and the neighbor is going to come testify, it's nonstop, continuous, more than 30 days, you might get to fine stage. You might continue it to 60 days and get it to the lawyer. But again, that witness, you're going to have multiple witnesses who are willing to testify. It's nonstop every day for 30 days to get to a fine, and then nonstop every day for another 30 days before you get to the lawyer. That's a lot of time. And if they stop one day and there's no smoke, you have to start all over again, right? And that's what's killer about 1137, because all that has to happen to stop a case in court on any of these things is say the homeowner who is supposedly smoking nonstop say, well, it definitely stopped, it didn't go past 30 days because I was out of town one day. Okay, so that's the difficulty with these kinds of things. They're immediate instances and they're not going to continue past 30 days. So if you've got that smoker and you've got the neighbor who's complaining about it, you're going to have to tell them they have to go talk to their neighbor. You're going to have to tell them that they need to reach some agreement between themselves about how they're going to deal with it, because you're never going to get to the point of finding. Okay. It's really, if you're trying to stop it under a nuisance stop provision, you're going to need multiple people saying the smoke happens nonstop from every day for more than 30 days. If you have a HOA that prohibits smoking entirely, okay, you don't have to get multiple witnesses, but you still have to have at least one person who's going to say nonstop every day, never stops, right? So it's very difficult for you to get past and to deal with these things, okay? What about the body odor or the unit being so unclean? And this generally happens because of hoarding. Whenever I've seen these, someone calling me saying that the unit just reeks, and it's because they're hoarding. That one, what you want to look to is trying to get to the Department of Health and Human Services, right? Or the fire department, because both the fire department and Health and Human Services can come into play on hoarding to try and help you. Because hoarding is an issue. One, these are going to be easily lasting more than 30 days, more than 60 days. You're going to be able to get these to the lawyer's office because they are going to go on for a long time, right? That's not a problem. That one is generally one that is not limited in duration. It's easy for you to get an issue in front of the board, get a fine, and or get it to the lawyer, because these are not short-term instances. And so even though they are going to fall under the nuisance category, you are going to use, you're going to be able to get to fines and to the lawyer to help you. But oftentimes what you're going to want to do on those is you're going to want to reach out to other agencies like Health and Human Services, because hoarding is a mental issue, right? So you're going to want to get to that. And you're going to want to get to the fire department, because hoarding is a fire hazard to the neighbors. And so that's something you want to deal with, okay? Paint or new carpet. Why do I list that? Because we're running into more and more people who are telling us that they have a sensitivity to paint smells, right? And that sensitivity on the paint smells is so bad that they're demanding that the HOA take action or do something, right? Again, this is one where they're going to need to talk to their neighbor if they have an issue with that. And it might be an annoyance or a nuisance to them, but there's nothing that obligates you to do anything simply because they're super sensitive to it. On the marijuana, sometimes that's going to be a health issue that you're going to care about, because it may be a health concern to the neighbor. And so that may limit you to a 3-day concern. That might be something that you can do, right? And that might help you. So use the health concerns, if you have them, to make it a 3-day shorter window on the marijuana. You might try the 3-day on smoke, but I really think that one will probably fail. We've not seen a lot of successful cases on smoking. We had some admissions by some courts saying that, yes, smoking clearly does have health concerns. So we can probably try that to shorten your smoke or marijuana effects on neighbors to a 3-day rather than a 30. But that's the only smell one that you're going to be able to limit, okay, and shorten it down to that 3 days rather than 30. Had a question, what about noise complaints in unincorporated areas? Honestly, I'm going to tell you to throw your hands up and tell whoever's complaining that the only option they have as neighbors, one, if it's an unincorporated area, normally those parcels are larger, right? And so there's a little more distance between the neighbors. So it's going to have to be a heck of a party or really, really super loud for the neighbor to hear it, because you don't often find the housing as close together in the unincorporated areas as you do in the incorporated areas. That's not always a fact. Sometimes you still have the multifamily units in unincorporated areas, but their only option is going to be that they can go sue their neighbor. You can't, but they can. That's your only option. A question was about animal control and police wanting to speak to the eyewitness. Anytime police are called, they always want to talk to the eyewitness, which is good for the managers because anytime somebody calls you and wants a report to the police, you can explain to them, hi, police don't want to talk to me. I didn't hear it. You heard it. So anytime a homeowner calls you and says, you need to call the police, your answer is, no, I don't, you do. Police aren't going to want to hear hearsay. Police are not going to take the manager trying to make a report of something you didn't see and you didn't hear. You're not the eyewitness, so definitely refer them over to the person who was the eyewitness. As I said on the hoarding, this issue is something that causes smells, mold, fire hazard, rodents, insects. This is something that you're going to want to refer out to other agencies to help you on that. And that's, again, a lot of this is kind of a benefit to the manager because you're going to say as a manager, I can't take action, right? Here's who can. On hoarding, you can call the fire department. On hoarding, you can, it's a health, it's a safety issue. You only need 3 days, but you're going to have more than 30 because these things take forever to come up. They don't go away quickly. You're going to have plenty of time to meet your 30-day requirements. But you could use a 3-day letter if you want at the smell because there is a fire hazard. If you really have proof, if somebody's seen, even if it's just a peek, and you have a neighbor say, there's no room for anybody to maneuver in there, that's a fire hazard. That's a 3-day warning. So if you want to do that, you certainly can. Any recommendations for navigating situations where the police were already involved? Complaint filed with the police, then the homeowner turns back to the association, wants you to enforce the HOA rules. Again, it depends on what the situation is. If the police were called for noise, you can explain to the homeowner who wants you to send a letter in addition to the police. I think it's a good thing when it's a tenant situation, right? Because you can then send the letter to the owner telling them the police were called, but you have to wait 30 days. And if it doesn't reoccur within 30 days, there's nothing you can do. If it does stop and then there's another call of the police, that's a new incident. Again, it has to continue past 30 days for you to get to a fine. So there's not a lot you can do other than one letter each time the police are called. You're never going to get to the fine stage. What section of Kiowa covers common property use? So Kiowa section 302 gives you the ability to draft rules, right? And so that's the provision you're most likely going to look to. But the HOA owns their property, and so that's what gives them the right to write a rule about common property. There's other sections of Kiowa that define what common property is. That's in the 100s where the definitions are. But the ability to adopt a rule is in 302. I have an owner that cut down several shrubs and killed them. Can we bill the owner for cost of cleanup and replacement? It's going to be specific to your documents because your documents are going to tell you if, in fact, you have that authority, and whether or not someone did damage to your property. You're going to have to look to your documents specifically to get to that. Again, enforcement, one of the things that came up recently was a call that an individual is wandering about and has dementia. And I just want to remind all of you guys that as we have properties where we have homeowners who bought into these multifamily properties and they're aging in place, just like the property, HOAs are not parents, caretakers, counselors, or police, okay? You are not taking care of the individuals, okay? You cannot take care of that person who's wandering about on the common area and wandering about here and there. That's not your job. If they're bringing in things, you cannot force an inspection short of a lawsuit. You're going to need a lawsuit in place to get ability to inspect monthly once you get it cleaned up, that it stays cleaned up. You may suspect what's inside, but you can't force them to open the door to you. What about other nuisances that we see all the times that you can take self-action on? Trash, right? Let's say you have a homeowner who refuses to clean up their property. A lot of you have documents that say if an owner doesn't maintain or clean up, you can step in and hire it cleaned up. All right. So you could hire somebody to come over and remove all the trash and bill the owner if your documents say you have that right. Dogs off leash, dogs not picking, or owners not picking up after the dog. Again, these are not something that you're going to ever get to fine stage on, because you're not going to be able to have it continue nonstop for 30 days. So because it doesn't continue nonstop for 30 days, you need to look for self-help provisions. Right? You need to find out if you have in your documents the ability to hire like doggy or duty calls, right? And bring in duty calls and bill the owner for you picking up after the owner's dog poop. And if you have it, then you want to send a letter to the owner. You are violating the covenants. Under this section, we have the authority to hire cleanup for your violations. We are going to do so at a cost of X dollars a week for duty calls to come up and pick up after you, since you will not pick up after your dog. Make sure when you read those provisions about billing the cost back to a homeowner, that you make sure if the documents, and when I'm talking documents, I'm talking your declaration. This authority must come in the declaration. But the declaration gives you clear authority to hire the work done and clear authority to bill them back. You need both those things, right? Both the authority to do it and bill it back. And you need to look and see if there's a requirement of a hearing before you bill them. Because if so, you don't want to miss that step, because you want to be able to bill them back for, cleaning up after the dog. Off leash, all the cities, all the counties have leash requirements. Call it in. I mean, that's the best you're going to be able to do, because again, 1137 is going to make it so we can't take care of it. So make sure we're using things that are going to happen and deal with it. Right now, parking is something that our hands, we're really, there's not a lot we can do right now, right? Because if it's parking on the city street, the statute says you cannot stop somebody from parking on a city street. So if it's a city street, you're stuck there with parking. If it's on a private street, you have to follow the tow law as it currently stands. But right now, as we all know, that's one of those lovely bills that's trying to work its way through the legislature, that if you tow, you have to pay, you, the HOA, have to pay for the tow. You have to pay for storing their vehicle. So it may be that there's going to be no ability to tow a vehicle anymore. And so your parking control is diminishing day by day. Right now, if they're parking in the street, there's not much you can do. I have a question here that says, my HOA community has very narrow cul-de-sacs. City code requires access of at least 20 feet. Would this be considered public safety issue? Again, you can't take action for parking in a city street. So there's nothing you can do on that. If it's a city street, they get to park there and you don't get to enforce it. Regardless of whether it's a public safety issue or not, the other statute on city street parking is going to prohibit you from doing that. Pool violations. We all know the pool violations are going to happen and be done long before you, the manager, even find out anything happened. So what do you want to do? You really want to look to your declaration, see if your declaration gives you the authority to suspend use, right? It has to be in the declaration. It has to say that the association has the right to suspend use of the amenities for violations. And if so, redraft your rules that say violation of pool rules will result in immediately being suspended for use. Because it's the only authority you got anymore, guys. 1137, we're not going to have continuing pool violations. So if you want to address the pool violations, you're going to have to look to your documents and make sure that there's something in your documents that stops or allows you to suspend their use. can we just prohibit animals? Yeah, if you amend your declaration. But obviously, you're still going to have some, because every owner is going to go online and decide they're disabled, and they're going to go get a letter, because it costs $100, $150 to get a letter. And so you're still going to have all the requests that you're going to have to sort through to see if they really do meet the standards for FHA. You'll obviously still have some animals who are ADA service animals. They won't ever be a problem, though. You can kind of pretty much ignore that. Just so you know, there's two different types of animals that are always allowed, regardless of what your documents say. And that is, if owners are disabled, they have a right to have a reasonable accommodation to have an animal with them. And that's what gets you ESAs, emotional support animals. ESAs are only allowed in the home and the common areas and all around the common areas, and in the clubhouse if they really are disabled. ESAs are not allowed into restaurants, grocery stores, etc. The only animals that are legally allowed in grocery stores are service animals, and that's under ADA. The service animal has been trained to do a task. And so those animals are what you see is a seeing eye dog, or an animal that alerts to let somebody know they're going to have an epileptic fit or a seizure, or they're going to have I think they've even been trained on blood insulin issues, like some severe diabetics will go into shock, and the dogs are trained to know they're about to go into shock. So those are service animals. They are trained to task. That's what ADA is. Trust me, you will never care about a trained service animal. Those dogs are so brilliantly trained, and they have one focus. You guys tell when it's really a true service animal, because that dog doesn't look at anybody in the room. It looks at its person and watches its person, because that's its job, and that's what it pays attention to. You'll never have any problem. You'll never worry about that. It's the untrained ESAs you'll have problems with, because they're not trained. So even if you do amend your documents, you're still going to have some dogs on the property. This is something that we're getting close to the point where we can't fix. Okay. Street parking, something we can't address. And because of the fact that we can't tow anymore, or it's going to be very difficult to tow if this new bill goes through, this may be impossible to fix. As horrible as this looks, and it has, all of us would say, this is awful, and this is why I want to live in an HOA, this kind of circumstance might be something our hands are going to be tied with. If that new bill goes through, we may be able to do nothing. And the problem with 1137 is all of those cars have to stay in that spot for 30 days. So, if any car moves on day 29, you get to start over. So it's going to be very difficult for us to do anything with something like this. And so we need to be aware that that may be something we can't do. Obviously, rentals are a problem and can be a nuisance. It obviously is something we care about because of, all kinds of different things, effect on FHA housing, effect on the community. If there are loud parties, it can affect the property values for neighbors. Renters, there's always a concern that they care less about the property. Just so you know, surveys tell us that about a third of all properties are held by renters. And we all know that we don't have 33% violations. So, and we all know that because we've dealt with owners who have been rooted in our face, that just because you're an owner doesn't mean you're not going to violate the covenants. So it's not always just the renters that are the problem. In our short-term rentals, these problems that are hurting our community, you can't fix it with 1137 in place right now. The only way to deal with this is to deal with the other issues, right? So you're not going to be able to deal with the rentals because they're 2 or 3 days. You're never going to get to the 30 days, right? How do you deal with the maintenance issues? If in fact you have damage, you're going to look to your documents and look for whether or not you have the ability to do chargebacks. And that's the only way you're going to be able to fix those maintenance issues, is you're going to have to look, again, outside the covenant enforcement realm. Go back to your declaration. Do you have the ability to charge the maintenance for damage done due to the wear and tear, right? And you're going to have proof of who caused the damage and then charge it back. Vehicles, because people are doing a short-term rental so they can have parties and the vehicles parked at the unit. As I just said, there's not much you can do with the vehicles. We may not be able to do anything. Security concerns, because when you have the short-term rentals, they get the codes to your high-rise units, and then they have the codes forever. And so how do you deal with that? That may be something that, if in fact you have a lot of that going on, you go to a fob system, no codes, make it almost impossible for the short-term renters. They'll have to pick up the fob and then drop it back off. That reduces the codes and the security concerns. Obviously, using fobs isn't going to fix everything, but that's one way to address it. I don't have any outside-the-box fixes for the property values or the housing shortage. The insurance issues, if in fact you have that, you may want to work with, can you allow the short-term rentals on condition of extra insurance? That might be something that you want to deal with, right? Is that, hi, we can't shut it down. We can't get a short-term rental prohibition amendment passed. Maybe we can get an amendment to the deck passed to increase insurance if you do short-term rentals. You're going to have to think outside the box and outside covenant enforcement to try and deal with some of the issues we're running into, because 1137 has tied our hands to the point that there's not much we can do with it, right? Look to amend your covenants to deal with adding the rule that the advertisement for the short-term rentals is a violation, as well as the short-term rental itself. Make sure that your rules state you need to see a copy of the lease, right? The state law, the state cases just aren't helping us. They're saying it's not a commercial use to do short-term rentals, so we've got to think outside the box, right? So amend your rules. The other thing is use your state and cities to help you, right? Because the states and the cities are all helping us by adopting their own rules, right? Denver requires the owner has a license and they have to register. Aurora requires a license and makes them pay taxes. Boulder requires a license. Vail requires a tax license. If you can use the city laws to your benefit, that will help you, right? And that's your best bet to deal with those, okay? There are some others that are slightly easier only because they're around longer. We're not going to run into the 30-day 1137 hurdle on these. They're still very difficult because, how many times do the hardwood floors go in that you didn't know it because they went in so fast, right? And or once you start enforcing against them, you get claims that it's necessary for their allergies and their disabilities. So for hardwood floors, you really want to look at kind of looking into maybe soundproof, right? Looking to how to deal with allowing kind of that compromise. Allow the hardwood floors so long as they deal with sound mitigation, whether that's with rugs or underlayment under the floating floors. Again, you want to kind of take a look at that. Obviously, the other issue we see sometimes, it can be a nuisance type issue, is businesses that has use inside a unit. It causes all kinds of different issues that you're going to look to, and you're going to want to go to external resources to try and deal with these, because traffic for a business isn't going to be continuous for 30 days, right? The electric usage, see if you can look to your declaration to go to sub-metering for both electric and water. Spring Showcase had a company that has sub-metering to deal with electric and water usage to help you take that impact off the HOA, right? Those kinds of things are look to local building codes, right? That might help you if in fact they're making changes. Health department, if maybe what the business is doing is a health issue to the neighbors, right? And if it's a health issue on how they're using it, I had a guy who set up a welder inside his home. That's a health issue because there's all kinds of ventilation that had to be done. We can use the 3-day health and safety. So those are some of the things you can do on some of those nuisance type issues, right? But again, if it's inside the home, may need to be by a declaration amendment, or again, we may need to use just our the police and or code enforcement to help us stop it. I have a whole bunch of questions here. Let me see if I can get through all those. Is a certified letter always required when a violation is cured? The cure letter does not need to be certified, but there does have to be a cure letter that's pursuant to 1137, right? There must be a certified letter of the notice of one of the violations. So you have to send a 30-day letter before fine and another 30-day letter before it goes to the attorney. One of those must be certified. If they cure, you have to send a letter. It does not have to be certified, but you do have to send a cure notice, and the cure notice has to say if any fines were imposed during the violation. The police aren't familiar with the legislation, which is unfortunate. Yeah, and they do try and deflect issues, but sometimes you can get the police to come out. I've had police come out when they say, look, I know the police officer has said they did not believe what happened was harassment in their opinion, or it didn't rise to the level of a crime, but they were willing to go next door and talk. And just the police showing up and talking to the homeowner who's doing something sometimes help you. What do you do when police are called on a police matter and they're telling homeowners it's private property, they need to talk to the HOA? Every property is private. Police are looking for an out, folks. Come on. If there's a murder in my house is private. I got news for you. The police have authority to come in my house. Police are looking for an out. Again, if homeowners tell police to enforce the covenants, cops are going to walk. Homeowners need to call the police and say the yelling next door, there's drug dealing next door, but police aren't going to take those calls unless the homeowner gives them facts which prove a crime occurred. Homeowners are calling you because they don't have facts. They want you to do something because they know they don't have the ability to call the cops, and they're trying to make it your problem. You just have to go back to the homeowner and say, look, I don't have any witness tests. I'm not the eyewitness. I didn't see anything. I don't know what happened. I can't help you. You need to call the cops. How about homeowners who complain about an upstairs neighbor flooring, stating it was changed and is loud? You can go back to the homeowner and say, I can send a letter to the neighbor, but if the neighbor tells me this was installed over a year ago, there's nothing more I can do. And again, it's about communication and explaining you're not unwilling to act, but you have limitations on what you can do. And so you tell them, here's the law, and here's what it says that I can do. And so if it's beyond a year, I'm stuck. My association's updated and amended enforcement policies from 2017. That's not compliant with the law from 1137. You need to get them to update it. Nope, there's no plans to rewrite 1137 in regards to the covenant violations. They told us right after they wrote it they would, and now they have backpedaled and they've refused to do anything. Are we able to send courtesy letters? Absolutely. You can always send courtesy letters. And what we learned as managers, I think most of you know that courtesy letters shut down a lot of violations. That's why when we wrote covenant enforcement policies, we wrote that warning letter, kind of the initial letter that was a 10-day letter, because a lot of people want to be good neighbors and will stop after that letter. And so certainly you can send that letter. And a lot of times it'll stop, and you'll only get the ones who absolutely refuse to comply, who are going to continue doing it. But at least that limits it, right? It reduces the people violating it. In a condo complex where smoking, vaping is only disallowed in common elements, and that does a unit owner have a right to smoke inside their unit if a neighbor is complaining about the smell? Yeah, smoking is, if there's no prohibition against smoking in a unit, there's no way for you to take it to court. You're never going to get there. 1137 means it's got to be a nonstop complaint. You could probably try a 3-day letter, but you're still going to have to get multiple people saying that the smoke violated them. If you only have one neighbor, right, next to your smoker complaining, I don't think your court's going to say that's a nuisance under the law. Single family home, garage is packed with junk and neighbors are complaining of mice. They state the mice are coming from the garage. Well, single family home, where's your right? Go back to that first slide. What's your authority to care what's in the garage? Go back to your neighbors who are complaining and say, tell me what I'm supposed to cite the neighbor for. There's nothing in the documents that say anything about what he can pack in his garage. So where's the violation? Go talk to your neighbor. I don't have a violation, so there's nothing for me to do. 2017 rules talks about fines of 1,000 and 2,000. What that violates the state law. 1137 limits your fines to $500. I keep getting long buffering periods. Oh, sorry, I can't help with that. What about cat food being left outside that neighbors say is attracting mice? Look to DOW or your city codes. We had that in Colorado Springs, and Colorado Springs City Council said you can't put food out because it attracts wildlife. And so the city code was awesome, and we got the city to write the people up who were putting food out. Look for our city code. A lot of areas on the kind of Golden, I think, has a city rule against that. Jefferson might as well. See if you can find a city code, because then you can make it their problem, the city, not yours. Can a rule be adopted to prohibit hoarding items on the exterior of a living unit? Yeah, probably, because it would be unsightly. You could probably find something, but again, you're going to have to look to when it's outside of a unit, what's the basis for your rule? You're going to have to tie it into something for the declaration. Otherwise, you're going to get an argument. You're trying to amend the declaration without going through a proper process. What about repeated chronic violations that don't meet the 30-day threshold? You need to get that board to agree to be a test case for me, and I'll do it. If you get somebody who's willing to repeatedly park their car every day for 30 days, but they move it every day, but they still do it every day for 30 days, I'll take that as a test case. I don't know what the court's going to do with it, and we may lose, but I'll try it. Habitually not picking up after your dog. My main recommendation on that is look inside your declaration for authority to bill back fees for the cost of cleaning up, and then hire duty calls. Again, chronic nuisance violations, we have to think outside the box, guys. If the pool is in a common element, you can draft rules, because again, we control the common elements. But what you need to do is find in your declaration on the pool the ability to suspend use of amenities. If you can suspend use of amenities, then draft your pool rules that if there's a pool violation, they're going to suspend the use immediately. If decks were to be updated, revised to disallow pets, how does grandfathering apply? So when you amend your declaration, you don't have any requirement under the law to grandfather anyone. So you could write a new rule right now that says nobody's allowed to have a pet. And if it passed, and you got 67% to do that, everybody has to get rid of a pet. Problem being is if you have a lot of people who already have pets, they won't vote to approve the amendment. And that's when grandfathering comes in. People say, we will allow you to keep a pet if you have one right now in order to get the amendment to pass. And that's why there's often grandfathering in amendments. It's not because it's legally required, but it's how you get it to pass. What about lights from one homeowner to another when the house is back to back? One would presume, depending on how the light works, it's going to be there more than 30 days. Maybe you can get to the fine stage on that one. And if your documents prohibit lights that glare to another, you'll get to fine stage. But if they turn it off on day 29, you're starting all over again. A neighbor here puts ADA vest on their dog. It's doubtful it's real ADA. Any way to ask for proof? No, there's not. Again, on ADA, if it really were an ADA, you're allowed to ask what task the dog is licensed or is trained to do under ADA. Okay, what's your dog trained to do? You can ask that question. But again, ADA doesn't apply. If in fact you have a no pet community, then somebody brings a pet to your community, you can say, if you'd like to request a reasonable accommodation, please go ahead and produce for us reliable documentation that shows you are in fact disabled. And please tell us why you need the dog for your disability. How are metro districts affected by all of this? It depends. If they're enforcing their covenants under Kiowa restrictions, they have to apply with all that. Is there any additional legislation coming to fix it? Nope. How can we deal with trailers, RVs? They move them and you have to start again. I wish I had an answer outside the box. I don't have an answer on that one because they, like you said, they move them and you're starting over again. I don't have something. Good scripting. Ooh. How do you stop? I'm sorry, I sound like I'm babbling because I'm reading the question and I have no answer for how to stop people who are trying to pit the HOA against other owners they don't like. You'd have to send me what they're actually saying, and I could try and give you a response of which statute prohibits what they're trying to do. Can a management company bill back an owner for the administration fee of sending a violation letter? So that's really not clear under 1137 because 1137 talks about some things that specifically you can't bill back. And then it talks about other things that you can in other parts of Kiowa. And so they're kind of at odds with one another. They've never cleaned that up. There is supposed to be some cleanup to 1137's collection portions. Maybe they'll pick up and clean up what you can bill back for and what you can't. I don't know for sure. I haven't heard where that legislation is right now, but there has been some discussion on that possibly being cleaned up. But right now, Kiowa is at odds because in one part you can say you can bill it back, and other parts you can't. Can this include any? Yes. If any surface has been in place for 4 years, can you do anything? No. 4 years is long past the statute of limitations. Can business trash be a violation? Well, it depends on the covenant. If they're not picking it up, if they're not addressing it according to the covenants, it can be. Again, I don't think it's a health hazard, but it's, you know, if they're, it's going to have to look to that, you know, very first slide. I said, do you have authority? Yes. Well, is a parking lot a common element? I don't know. You have to look to your plat map. Plat map's going to tell you what your common elements are. That's your key. You always want to get your plat map so you can tell that. Homeowner needs to stop, avoid, talk to their neighbors. Amen. I got you there. Board asking for violation notices to be sent for a rule that's non-existent. Go back to the homeowner or your board members. Explain to them you can't do anything, and that if you start drafting letters and violations for nothing, it will make you look stupid in court when the homeowner sues you for harassing them, right? If your documents don't prohibit something, and in fact, you still send the violation letter, that homeowner can say this is harassment and sue you, the association, for harassment. So tell them that if there's no, there's nothing in the documents that say something, then you can get in trouble and you're giving the grounds to the homeowner to sue you. Guys, I'm way past my limits here. I think I've hit most of the questions because some of these seem to be duplicates that I think we already went through. Ever think of doing a homeowner target video? Well, the problem is those who want to comply do, and those who don't want to comply would never listen. Wouldn't the HOA be in a precarious situation if it suddenly prohibited all pets? Again, you can do an amendment to the declaration that says we're going to allow no pets in this community. Homeowners have to vote on it. If homeowners all vote, if you get 67% of the homeowners all voting on it, it goes into place. That's it. The problem is if you already have, 40% of your homeowners having pets, you won't get 67% of your homeowners to approve the amendment. The glare only comes on with movement. It's not on consistency. Well, then it's obviously it's turning off. It's certainly not on 30 days. You're never going to get to the 30-day rule, so you're never going to get anything. So for that light violation, because it's a motion sensor light, what you're going to have to do is tell your neighbor to go talk to their neighbor. Yeah, we do have some cleanup coming. Let's hope it happens. Guys, I think we're out of time. Thank you all for your questions. I think I hit all of them. Good luck. And yes, this session was recorded. You should have gotten that notice when you logged on. And yes, they will be available later. Thanks all. Take care.